you all hear me okay? Yes. Is that a little better? All right. Well, I want to thank everyone for being here on a Sunday afternoon, and I want to thank all of the sponsors of this event. And I especially have to give a shout out to the League of Women Voters because I've had the honor of representing the League in their ongoing efforts to challenge in the courts some of the voter suppression tactics that the three of us are going to talk about today. So while I have to say as part of my job, join the ACLU. I hope the ACLU will excuse me as saying, please join the League too. So they're a great organization. So my task this afternoon is to provide you all a general overview and the landscape of voting rights around the country. And then Chad will get more into the specifics of what's happening here in Texas. One of my colleagues at the National ACLU Voting Rights Project wrote an article that I believe was posted in the Washington Post, and he talked about how we're in an age where lawmakers are being allowed to choose their voters, even though it's supposed to be the other way around. And so when you think about issues such as voter ID and proof of citizenship, and the pushback on issues such as felon disfranchisement, allowing people who have committed crimes in the past but want to reintegrate into society, all of the pushback in terms of allowing them to exercise a fundamental right to vote. These things are efforts really to limit or minimize, reduce our electorate. And although the efforts, again, of the League, of the ACLU, the Lawyers Committee for Civil Rights Under the Law, and so many other groups, we remain steadfast in challenging these restrictions, it's really going to take you all in order to exercise your right to vote, share the information you learned today with others, and then be active in pushing back on these measures. So we can't do it alone, and I suspect that you're here because you already recognize that. So that message is really for the folks who aren't here today. I am going to be providing you a very quick snapshot of what's going on around the country because we just simply do not have enough time to go into the level of detail that a lot of these bills go into and all of the ramifications. But I'm going to start with voter ID, again leaving Texas for Chad, but talking about what we saw once the Supreme Court in a case called Crawford v. Marion County ruled that it was not unconstitutional per se for a state to have a voter ID or photo ID law for purposes of someone to vote. And the court set the standard that in order to prevail in a challenge to a voter ID law, you have to really be able to present the evidence that it will have the discriminatory, disparate impact that we maintain and in many cases have been able to prove that these laws have. So after that Supreme Court case involving Indiana, you had Arizona, Georgia, Texas, South Carolina, North Carolina, and the list goes on of states that felt that now they had the authority, the legal authority and the legal cover that they needed in order to promote these types of voter ID laws. One of those cases that I was involved in involved a challenge to Wisconsin's voter ID law, which was considered to be one of the most restrictive in the country. It didn't allow for certain types of student IDs. It didn't allow for non-Wisconsin driver's licenses to be used as evidence or proof of that you are who you say you are. And so for these and many other reasons, we brought a legal challenge to that law. And our clients in that case included a woman named Ruth L. Frank, who was born in Wisconsin, but didn't have proof of her birth. She didn't have a birth certificate. The best that she had was a document from the Register of Deeds that proved she indeed was born, as if her physical presence wasn't enough for that. But that document contained a misspelling in her name, and so Wisconsin wouldn't accept it, even though she had been voting without any problem since 1948, even though she had served as an elected official in her neighborhood, and even though she had never missed an election, I believe, since she first started voting. Nevertheless, she was one of the people who was going to be impacted by this law, and she was also a senior citizen who had over the decades understood the power of the vote, We just were talking about the importance of women gaining the right to vote, and Ms. Frank was an example of someone, a woman, who once she had that power, used it for good. And now the state of Wisconsin was trying to take that away from her. Another plaintiff in the Wisconsin case was named Eddie Lee Holloway. He is a disabled individual. As a result of his disability, became unemployed, and as a result of his unemployment, became homeless. He had a misspelling on his birth certificate. He was named after his father, and so instead of it saying Eddie Lee Holloway Jr., it said Eddie Jr. Holloway. But the necessary powers that be wouldn't accept that as just a mistake on one of his documents. So he said, okay, well, I have an expired Illinois photo ID. Will you accept that? I'm sorry, Wisconsin ID. And Wisconsin said, no, we're not going to accept that either. If you really want to vote, you're going to have to get your paperwork corrected. And if you want to get your paperwork corrected, you're going to have to pay for it. Yes, you disabled, unemployed, homeless individual are going to have to find some money, not to pay for a place to live or to feed yourself, but to get an ID in order to vote. And these are just two examples of the types of individuals who have stepped up on all of our behalf to challenge these onerous restrictions. We were very happy that a lower court found Wisconsin's voter ID law to be unconstitutional, but we were hit with a surprise by the Seventh Circuit when they said that the injunction that the district court put into place was too broad. They didn't feel comfortable with an affidavit that just said, I don't have the documents, it's going to take a lot of hurdles in order for me to get it, but I'm attesting that I am who I say I am, and therefore allow me to vote. And the Seventh Circuit said, no, that's not enough. You need to establish with particularity it would be an unreasonable hardship for you to obtain the underlying documents in order for you to get a photo ID, in order for you to vote. And that is the standard that we are challenging now in Wisconsin. So it's like we won the case, but we didn't get our victory. We're still fighting for our victory. And that is a situation in many places, like in South Carolina, where we were successful in temporarily blocking the photo ID law there. Like in Texas, where the fight has been successful, but it seems like never ending. But I know we'll get there someday. But I don't live in Texas. You all do, so you have to make that happen. And then Alabama, a place that instituted a photo ID in the midst of all of these cases happening, and said, well, we're just going to wait and see how these cases turn out before we put our photo ID into effect. And then once they felt that they got the necessary clearance, Alabama instituted its photo ID law. But at the same time decided that it was going to close the primary agency that provides the photo ID. It closed about 31 of its DMVs around the state. And coincidentally, because I'm sure they didn't know this, those DMV offices were in predominantly African American communities. In fact, they were places where over 75% of the registered voters where those DMV offices are African American voters. And so we don't believe this is just a coincidence, and we think that some of the other cases that have been brought have done a very good job of showing that this is not just an effort to eliminate or prevent voter fraud, which has not been clearly established, but it's really, again, an effort to block people out of the electorate so that the policies that we're challenging in other aspects of our lives continue to perpetuate. So that's a little bit about voter ID. We've also had to deal with proof of citizenship. Now, even though, for example, with the federal form that is required to be provided under the National Voter Registration Act, when you fill out that form, you check off an oath that says, yes, you are who you say you are, and yes, you are eligible to vote in the United States because you are a citizen of the United States. Whether you were born here or you were naturalized, you are eligible to vote. Under penalty of perjury, you check off that box. And there is no evidence that we've been able to uncover to show that there are non-citizens or others trying to mess up our election process who have been signing that form falsely, and therefore that non-citizens are being allowed to vote. Nevertheless, Arizona was a state that took the lead in pushing for a proof of citizenship requirement again, even though there was no evidence that such a requirement is necessary. And in 2013, the Supreme Court said, no, you can't do that, Arizona. You at least have to get the Election Assistance Commission to say it's okay for you to include that requirement for a federal form. And for 3 years, we were successful in pushing back against any approval by the Election Assistance Commission and authorizing that additional voting requirement. Unfortunately, in January of this year, the executive director of the EAC, Brian Newby, sent a letter to several states saying, without explanation, that now those states could require proof of citizenship. And so the League was one of the main leaders in challenging this requirement on the grounds that, number one, you didn't provide an explanation as your own policies require. Number two, in order to even promote or to institute such a policy, you need to follow the Help America Vote Act requirements that say you need at least 3 commissioners to co-sign on such a requirement. Number three, you didn't offer any notice or comment period to individuals so that the public could raise questions, concerns, or even outright opposition to this additional requirement for purposes of voting. And number four, your own EAC internal policy states that your requirement is not even necessary. So again, what is the motivation behind this policy? And so finally, their catch-all claim is that the executive director just acted completely outside the scope of his authority, and therefore that this requirement should not be imposed, at least not for the most upcoming elections. And we're so glad that a district court in Washington, D.C. agreed with the League and the other plaintiffs. The ACLU was also one of the challengers to that law and has blocked that law from going into effect, at least until the entire case is resolved. And proof of citizenship is a very important issue and can be a red herring, as we experienced in Florida, where our very wise governor, Rick Scott, decided that he also was concerned about voter fraud and non-citizens voting, and so he instituted a voter purge to clean up the rolls and try to get our supervisors of elections in our counties to support him in this effort. The initial purge captured over 100,000 people who, again, just coincidentally happened to have Spanish surnames. And then after litigation and time and advocacy, that number from 100,000 was reduced to about 100. And even that 100 is still questionable in terms of whether or not they were properly flagged. So when we talk about proof of citizenship and the negative impacts it has in terms of suppressing the vote, it's real. We have been able to at least establish that through our data that yes, you are capturing people who legitimately have the right to vote when you institute these types of voter purges. And another effort in terms of voter purging has to do with this program called cross-check. I don't believe Texas and thankfully Florida withdrew from the cross-check program, but it's this effort to have this kind of national database of voters so that if someone moves, one state will be able to say, well, is that person registered in your state? Have they really renounced their residency in that state? And if there's a question mark, then you get purged from the voter rolls. And we already know there are a lot of problems in terms of record keeping, that a lot of the databases upon which they were relying were never even intended to be used for purposes of voting. And so that's something that we've been pushing back on. But today there are about 26 states that have signed up for cross-check. So again, that's something that you all should be very aware of. Another effort of voter suppression, you all are probably familiar with what happened in North Carolina, where they had the omnibus bill that got rid of 1 week of early voting, that eliminated same-day voter registration, and that eliminated out-of-precinct voting. Now this was even though from the data review from the 2008 and 2012 elections that 2.5 million citizens in North Carolina took advantage of early voting. And of that, about 75% of African Americans in North Carolina took advantage of early voting and same-day registration. and that even if you were voting outside of your precinct and you didn't want to, or you couldn't really manage to get to your proper precinct, you at least knew that when you cast that ballot, your vote for president and your vote for governor would still count. And so for North Carolina to institute this bill was something that we again call voter suppression. It's under that umbrella, and that we challenged with the league, again, in ACLU and many other organizations successfully. And the decision we got out of the Fourth Circuit Court of Appeals was not only important because it struck down this law, but it was also important because it was one of the few instances where our arguments that these laws are racially motivated, that argument was adopted by the Fourth Circuit. The Fourth Circuit looked carefully at the record and determined that, number one, North Carolina had reached a point in its history where there was starting to be some parity between blacks and whites when it came to voter registration and voter turnout. The court took seriously the fact that after Shelby County decision, that was the Supreme Court decision gutting the most important provision of the Voting Rights Act, that a day after the Shelby County decision came out, a member, this is how the court described it, a member of a party that gets very little black support introduced a bill or announced that it planned to introduce a bill that would contain all the provisions that I just mentioned. The court also noted that before this bill was enacted, the legislature did an analysis on its own to determine voting statistics based on race, to see who is voting early, who is taking advantage of same-day registration, what is the impact of out-of-precinct voting, and of course, the racial impacts were very clear. And yet the legislature passed this bill anyway. So for these reasons and many more, the Fourth Circuit determined that this law was enacted with a racially discriminatory purpose. And again, to have such a decision and such a ruling is just, it's key. Because we're living in a society right now where a lot of people want to believe we're post-racial, but we're not. And although we shouldn't have to rely on the courts to pronounce that for us, that's just the situation we're in. So we needed a court, a federal appellate court, to find that such a law was racially discriminatory, as we were able to prove here in Texas as well. Felon disfranchisement, that's another issue that I spent a lot of my time when I was at the ACLU National Voting Rights Project working on. The idea, again, that if you have served your time, you're paying taxes, your children are going to public schools, you're paying into our roads, into our libraries, into our general community, you should be able to have a say in how your tax dollars are spent. You should be able to have a say in the curriculum that's being taught in the schools, and you should have a say in the various institutions that your community promotes. Because there is no question that having that kind of interaction with your community is one of the #1 drivers in terms of eliminating recidivism. And yet, even with this hard data, you have a lot of states, unfortunately, that make people go through the prison, the parole, the probation, the paying all of your fines and your restitution as a prerequisite to getting your voting rights restored. And I live in Florida, which is one of 4 states that does not restore your rights automatically, even when you've satisfied all of those different criteria. It still makes you go before an executive clemency board and essentially beg for the restoration of your voting rights. And in a place like Florida, and Kentucky, and Iowa, Virginia, these are places that have waiting lists that are tens of thousands long, and you've had a lot of pushback against governors, like in Virginia, like our former governor, Charlie Crist in Florida, who've tried to use their executive power to streamline the process and make it easier for people to get their voting rights restored, and yet they continue to get, again, that pushback. So in Florida, once Governor Scott came into office, you had tens of thousands of people who were on the waiting list under our former governor's streamlined process. And we had a case in which an individual challenged the enforcement of Governor Scott's new policy to him, because he was already in the pipeline to get his rights restored. And the court said, what is it, too bad, so sad, this is the law that's in effect today, so you have to start all the way from scratch. And you had a number of individuals, many folks that I speak with on a regular basis, who are so disheartened and feel really beat up, and except for the fact that they know that voting is a key to so many other things that they want to accomplish in their lives, would really be ready to give up, because it's just such an arduous undertaking to go through. And on top of that, in Florida, where you have a 5 to 7 year waiting period before you can even apply in the first place. And then you had Virginia, again, a progressive governor who recognized that within his executive powers that he could also try to streamline the process. So he issued 2 executive orders that said if people meet these various criteria, then they should be allowed to get their rights restored. And the state legislature said, no, that's not your authority. Your authority is just to grant the applications on a case-by-case basis, but it's the legislature that's going to decide the process by which people get their rights restored. And unfortunately, the Virginia Supreme Court agreed with the legislature, and so now the Virginia governor is facing, and to his credit, is doing granting several hundred petitions a day, so that people can, again, get their fundamental right to vote. And then you've got folks in Iowa, for example, who've just gotten caught up, again, in these changing executive policies when we have someone new in power. So we had an individual, an ACLU case called Griffin v. Pate, in which a woman had served her time, completed her sentence for a drug crime. When she completed her sentence, there was a policy in place that, again, streamlined and would have allowed her to vote. So she submitted her application, she registered and voted. And then soon after she cast her ballot, she was prosecuted for election fraud. Because in between that time, the policy had changed. And even for lawyers, it's hard for us to keep up. So imagine a layperson who doesn't understand all of the intricacies and the legalese. She just thought, the policy said I could vote. I was able to vote, so what's the big deal? Well, the big deal is now she was facing criminal prosecution for doing something she thought she had the right to do. And unfortunately, an Iowa court found that she indeed did break the law and applied the policy in place that, again, was more onerous during that time span I described. So with felon disfranchisement, every time we make some progress, we get pushed back. But again, we just have to keep moving forward, because you're talking about a population that comprises almost 6 million people in our country. Some have estimated that if you put that number together and compare it to what it would be in terms of electoral college votes, it would be 10 electoral college votes that are wasted because people are completely shut out of the election system. So that is something that we continue to fight against. I want to talk a little bit, if I have time, about redistricting. I'm sure you all are very familiar with Texas' never-ending redistricting process. We're dealing with the same thing in Florida, where we just finished, 2016, we literally just finished our challenges to the redistricting process in Florida, which cost our state $10 million for them to have to now go through that process again in about 2 years. So it's not only a waste of money and energy, but it really is an antiquated system that we just need to do our best to undo. The idea of independent redistricting commissions is a very interesting one. I know that there have been experiments with that in other places, and perhaps it really is that anything might be better than what we're currently dealing with. But we do continue to have redistricting cases. ACLU filed a challenge against the Ferguson School District. I hope many of you were aware of the fatal shootings that happened in Ferguson, the riots, the rallies, the effort to improve the situation. And one of the things that initially got overlooked, but that we started to focus a little bit more on, is how did you get this system anyway? How did you get a system where you have a majority black population that is almost completely politically dominated by a majority white by a minority white community. And you get it when you have at-large elections, when you open it up so that people who don't even live in your neighborhood or your district are getting to still choose who your representative will be, which means that your interests are never really reflected and protected when you get to these agencies or these governing bodies. So the ACLU filed a lawsuit under Section 2 of the Voting Rights Act and under the Equal Protection Clause of our U.S. Constitution, arguing that Ferguson's at-large election scheme resulted in the denial and dilution of minority votes. And we were very happy that the court agreed with us in that case. It found that the percentage of the black voting age population, not just the total black, but if you just focus on the black voting age population, was almost 49%. It found that the white commissioners were either unaware or completely clueless, unfortunately, and probably willfully about the plight of their black constituents. And they found that even though you had some improvements in 2015 in terms of more black representation, that really was a special circumstance because you were coming right off of the heels of Michael Brown's death, when again all of this community action really helped to get out the vote. But that unfortunately, when you're dealing with a population that has such a low voter registration and turnout rates, that's dealing with serious socioeconomic situations, that you can't rely on one election outcome to dictate what their political power should look like in total. And so the court in Ferguson did outlaw the city's at-large election scheme. We've also been pushing on the issue of prison gerrymandering, and that's the system whereby several rural counties use their prison population as part of their total population when drawing their districts. So in one of my cases, for example, Jefferson County, it's a small county, not about 30 minutes east of Tallahassee. No more than 15,000 people. And yet one of the districts, District 2, was drawn so that 40% of the voting age population in that district was made up of prisoners. And so you can imagine what it means in terms of the political strength of people in District 2, the prison district, as compared to everybody else. They have greater access to their elected officials, which means that their elected official has a greater voice on the board, which means they're more likely to get the funds that they're looking for and the various resources for their particular community, because that's what increased political strength can get you. And so we challenged this election scheme under the one person, one vote principle of the 14th Amendment, and we were successful. It wasn't easy. We thought that just showing the bare numbers should be enough, but the court really wanted us to dig deep in terms of proving our facts and what the court called a representational nexus. So the court wanted to know, do these elected officials really cater to prisoners at all? So I was in the very interesting position of deposing the warden of the main prison in that area and deposing elected officials and asking them, you elected official, do you go to the prison and do any campaigning? Do prisoners get to the county commission and lobby on their issues? Do you answer any of their letters? What do you do for the prisoners? And the only answer they got is, well, you know, we consider them to be a part of our community because they come and clean our roads, and they deal with our trash, and they do free work for us that saves the county a lot of money. So it was very much an economic-driven relationship between the prison and the rest of the community. And the court ultimately found that that doesn't sound like a representational nexus. And so in an 86-page opinion that starts with the history of the one person, one vote, the history of the prison complex and the relationship or lack thereof between the prison and elected officials, that indeed this was a situation where there was a violation of the one person, one vote, and was the first district court, federal district court decision to find a violation in the context of prison gerrymandering. And this helped in another case that the ACLU brought in Rhode Island, challenging the city of Cranston's own prison gerrymandering system, where in one of the districts, if you counted everyone, including the prison, it was about 13,000 people. but then when you excluded the prison, that dropped the real voting population down to about 10,000 people. And in that case, the judge relied heavily on the Jefferson County, Florida case, and finding that, again, there was no representational nexus there. So prison gerrymandering is an area that we're going to have to continue to focus on, because when you exclude people from the ballot box, but then you want to take advantage of their bodies for purposes of increasing the political strength of others, that becomes very dangerous, and you're talking about almost a permanent exclusion of a segment of our population. So then the last thing I just want to mention is the Voting Rights Amendment Act. There's still efforts to get Section 5 back in place, and this bill, which I think is moving slowly along, it's not a lot of confidence that it'll get very far in light of this election situation, but it retains and strengthens a lot of the provisions that Section 5 already has. So if you have a history as a jurisdiction of racial discrimination in voting, you do have to get federal approval before you can institute that change. It could be a change of your election scheme, or it could be a change of a polling place. If it has a racially discriminatory impact, or could have such an impact, you need to get it approved by the federal government first. And it improves our notice requirements. Sometimes it was very difficult to find out what these voting changes were, and by the time you did, sometimes we didn't have enough time to comment on it, so it made the appearance as if nobody cared, when in fact it's just that the community didn't have enough time to galvanize and to organize so that we could put a concerted challenge in place. And so you have better notice provisions. Bail-in, in terms of expanding the number of jurisdictions that are covered. That was one of the main criticisms against Section 5 when the Supreme Court was looking at it. It was saying that you all are still punishing southern states for its history when time has improved, we've moved on, and if anything, there are other places like Ohio that they may not technically be in the South, but are still instituting some voting changes that have been successfully challenged as well. So the Voting Rights Amendment Act takes that into consideration and says, yeah, we're not going to just concentrate in one part of the country. We're going to say that if you have that history, you should be subject to the law. And then one last provision I'll talk about, it has to do with federal observers or monitors, especially in areas like in Texas and Florida, where we have a lot of language minorities in our community. So making sure that materials are in the language that people can understand, that they have the assistance when they go to the voting booth, in terms of making sure that their choice is well reflected in how they cast their ballot, and that they just generally understand what's going on so that they can be informed, educated voters. So it is my hope, and I know the hope of many others, that the Voting Rights Amendment Act, although not perfect, will pass in some form or fashion to reinstate the protections that Section 5 allowed. So I think with that, I'm going to open it up, or however you would like to.
Yeah, I think we're opening up for questions. So I'll just pass around this mic for people who
After you turn that, it's not.
Is it not on?
No.
No, we can't hear you.
Does it work now? The light's on.
That's 1, 2. Is that 1, 2?
Yeah.
Last one.
How about we just have people stand up and ask their question?
Or go down there.
Or ask no questions.
Want me to go?
Yeah. Work on the mic.
Which are the groups in the United States that are most in advance of trying to get these corrections? Is it the ACLU? Is it the Brennan Center? Which are the heavyweight groups that actually make the most difference when they make presentations in court?
Right, well, I think most of the cases that I'm referred to today, you will see the ACLU, you'll see the Brennan Center at NYU, you'll see the Lawyers Committee for Civil Rights Under the Law, and you'll see the League as actual plaintiffs in this case. So those are some of the organizations. The Advancement Project is another group based in Washington DC that does a lot of litigation. In fact, they, along with Chad, were my co-counsel in the Texas photo ID case. And then you have private attorneys, again, I'll mention Chad, who, you know, really, it takes a lot. It's very expensive, it's very technical to bring a voting rights case. And so when you have private attorneys making the time for a case where fees are not even guaranteed, and then who's going to cover all the costs, it takes a lot. But we do have the private bar support in bringing these cases. So those are the groups and then individuals.
Let me explain real quickly, because I'm approached all the time to give money to groups, and I'm just trying to figure out what's the best use of my resources. Is it to Brennan? Is it to the league? You know, and it's really frustrating
So,
not to
okay, I
know.
guess I'm supposed to say it's the ACLU. But that's not true. We are one of many, and we try to really work in partnerships. So I don't know, $100 spread it around? Yes.
So in these cases that concern photo ID or early voting or redistricting, sometimes you have groups that are coming from the civil rights orientation, and sometimes you have groups that are representing a political party, or maybe they're even elected officials themselves. Can you talk about balancing, you know, in these complex cases that you do, balancing representation of a community versus representation of a political party or political actors? How do you strike that balance?
All right, so the groups that I mentioned, we represent the communities. We don't represent the parties. And I'm very happy to say that I have represented Republicans who have been disfranchised and have tried to get their voting rights back here in the South, in Alabama and Mississippi. And, you know, and we have to be very careful about that too, especially on an issue like felon disfranchisement, where yes, we have the racial disparities, but the reality in terms of bare numbers is that white citizens are more impacted by felon disfranchisement laws than other racial minorities. Again, we have racism in our criminal justice system, which plays out into our voting system, but if you look at the bare numbers, it's mostly white Americans. And so I think that we have to, and we, myself and others, have to really be intentional about diversifying the face and the political parties that are represented. This is not just about getting Democrats elected, although in some instances, like in North Carolina, it's about making sure Republicans get elected. But overall, I think that we have to do a better job of talking about this more universally. And so that's how I try to balance. I try to remember who are the real people who are being impacted. Ruth L. Frank is a white woman, senior citizen woman. Lee Holloway, the Wisconsin case I was talking about, he's a black man. So you have a white woman and a black man who are both plaintiffs in a case challenging photo ID. And that's what we're trying to promote, that these laws are having, yes, discriminatory impacts on certain communities, but they're having a universal effect on all of us. Maybe one more? Go ahead.
Yeah, I think we have time. We have time for a couple more.
Okay.
Are you seeing a difference in rural areas versus more urban areas? So for example, the Austin area versus maybe, I'm from about 3 hours west, so you have an entire county that's 300 people, and here in the metro area, we're getting close to 1.6 million. So do you see a disparity between rural and urban areas in the work that you do, and kind of where those impacts fall out, or is it pretty broadly dispersed?
Absolutely, yes, I would say yes, I do. I mean, for example, Alabama, which I mentioned earlier in terms of the closings of the DMV offices. A lot of those were in what, the Black Belt. Rural areas, country towns, which don't have the same access that you would in a place like Montgomery or even in Mobile, in terms of having just greater access, more urban areas, more diversity, more options in terms of, something as simple as even having a post office. We, the ACLU, when I was with the national office, represented a Native American group because they had closed a lot of the post offices on the reservations, which meant that they weren't even able to access absentee ballots. And so absolutely, I think that there is some targeting of the rural communities because they have less of a political voice.
Thank you.
Yep.
So I know this could be like probably a whole separate talk, but what do you feel like is the most ideal system for getting people to the polls?
Next question. The most ideal, so I don't know, maybe that should be a group. I would love to hear what you all think. I mean, I'm in a situation where, get out souls to the polls, for example. Sunday is a great day. Even when we were driving here, when I was driving to the university, I saw a lot of churches, happening. That's a great day. So then you have a place like North Carolina who wants to eliminate souls to the polls. There was a time when you would get rides, they would organize mobile, voter registration drives, those things. I know that there's still small efforts, but it doesn't seem to be as coordinated, as frequent as it needs to be. So I don't think it's one solution. I think what we've been fighting for is multiple options. Early voting doesn't mean you can't vote on election day, but if you have to work or if you have kids, at least you have the option. Absentee voting. I wouldn't support something that says only absentee voting, but it should be an option. So again, I'm more in support of promoting multiple avenues for casting a ballot.
I think we have time for one more question.
Thank you.